Good evening, everyone, and thank you for gracing us with your presence this evening. My name is Jorick Gaines. I am a financial educator and advisor with WealthWave. We're the How Money Works company. We teach people how money works because it's not taught in schools, and most people have no clue how money really works. And I am pinch hitting tonight for Antionette Warren of Warren Publishing, celebrating, soon to be celebrating their 10th year in serving the community and elder abuse. And she had a pressing matter that kept her away tonight. So we'll get right into it. And first of all, I'd like to thank our sponsors, if you will. Alameda County Care Alliance. Is there anyone representing the Alameda County Care Alliance tonight? Care Alliance, going once. Unmute yourself if you are there. And also, since no one seems to be here, also the National Coalition of 100 Black Women serving the community and African-American women and their causes. Anyone here to represent, say a few words? Madam President on?
I don't think Dr. Hickman has made it on yet. This is Jackie Wright. I've been working with the National Coalition for 100 Black Women for a number of years. And currently I am the program director for the Doris Ward Workforce Development Program with the City of San Francisco, OEWD, and the Dreamkeeper Initiative. So we're pleased to be here tonight. Thank you.
You're welcome. And thank you for joining us. We appreciate it. So what we're going to cover tonight, ladies and gentlemen, I think I saw a gentleman on there. I don't know where the guys are these days. But we're going to cover one of my pet peeves, quite honestly, is the living trust. Because like most of us, if you're probably over 40, you've had some issues with someone passing and not having everything properly prepared, and it just creates I like to say they leave a nightmare instead of a legacy. And I've been doing this. This is my 25th year in business, and I've been serving working class folks, helping them understand how money works and the things they need to do for those 25 years or prior to that. And I still hold my California real estate broker's license. Not my focus, but I have it there in case I need it. And I've just seen just too much. And I love this because it's free. So they can't use the excuse of not having the money. There's no reason not to have those affairs in order. Of course, we know. And if you haven't heard, the biggest nation in the world is procrastination. And I have all kinds of stories I can tell about people that procrastinated. One recently, Christmas of last year, I had a 20+ year client that had bought a home out in the Sacramento area, got cancer, it was in remission. She called me up and knew she needed to get a trust for sure. Now I got her connected with a program that we offered. And I kept following up, said, when you gonna start, when you gonna start? She didn't start. Then I got a call the day after Christmas saying that the cancer came back with a vengeance and she passed on. And her 2 kids had to go through, probably still going through with all the court systems back up, going through probate. So that could go on literally for years and cost 30, 40, maybe even as much as 50 grand. And it's unnecessary. So I get get my feathers ruffled a little bit when I hear these stories because it's unnecessary. So we've got to get better at leaving a legacy instead of a nightmare. So Amy Chu is going to be the one that's taking us through the process and showing you how simple it is to complete. And I just want to say, if you haven't done yours yet, please get it done. Do it for your family. Do it for the people that'll survive you. Okay. So Amy, if you want to get started. Oh, incidentally, I'm going to come back and I'm going to show you what the California expenses are if you don't do a living trust.
Okay, So when you go to the freewill.com website, this is the first thing you'll see. And when you look over here, you'll see if you live in California, we also offer a free revocable living trust. And this is important to note because this revocable living trust only applies in California. Or at least I assume it does.
No, that's correct.
Okay. So you will go to this page, and to get started, you'll have to fill out this simple what's inspiring you to make a trust today, and you'll state your reason. Like, I have concerns about the current event, COVID-19, whatever. And you'll put where you heard it from, and if you're interested to give a nonprofit, and you'll just click start my revocable living trust. So you'll fill in your name and your email address to get started. And if you made an account, it'll take you to the login page. And you'll have to fill in your basic information, your gender, your birth date, phone number if you want, and your address. It asks you what's your current marital status, single, widowed, married, or domestic partnership, and what is the approximate combined value of the property you plan to transfer through your revocable living trust. And this is like a list of the things we'll go through: children and pets, successors and executors of the pour over will, asset distribution, funeral wishes, and the review and print process. So it asks you, do you have any children? If you do, it'll ask you how many you have and to put their legal names in. And it asks you, are any of your children under 18? If you click yes, you'll have to fill in who would be your child's guardian when you pass. Next. If you have any pets you'd like to provide for your trust. If you do, you have to fill in their pet name and a description of what they look like, I guess, and what species they are, how much money you would like to provide for your pet's needs. So like after you die, estimate how much it would cost to buy them food, veterinary costs, and etc. And in order of preference, who would be responsible for taking care of your pets if you pass? So full name of the first choice, say Ellen Smith, my relative. And if she is not available, it would go to the second choice. It's like John Doe, my child. And if you'd like to provide your pet caretaker with reasonable compensation for taking on this responsibility. If you do, click yes. If no, then no. Next. And next will be the successor, trustees, and executors. So in order of preference, what is the full legal name and relation of the person that will be the successor trustee of your trust and executor of your pour over will? And successor trustees. Your successor trustee is responsible for administering your trust after you pass away or become physically or mentally unable to manage your personal affairs. Your successor trustee will also act as the executor of your pour over will. A pour over will distributes any assets left outside your trust on the date of your passing into the trust, so that they're distributed according to your wishes. So once again, their name, their relation to you. Next. And this is where to distribute the distribution of your estate. And here are some important things to keep in mind. The grantor is the creator of the trust. They decide what property to include in the trust and who the beneficiaries will be. Residual trust property is the property that remains in your trust after all gifts of specific property have been distributed and liabilities such as tax and debts have been paid. If there is no distribution of specific property, the residual trust will consist of all property in the trust minus liabilities. The primary beneficiary is the first in line to inherit the trust assets or portions thereof when the grantor passes away. And the secondary beneficiary will inherit the trust assets or portions thereof only if the primary beneficiaries do not survive the grantor. And the tertiary beneficiary is basically the beneficiary after the primary and secondary do not survive. So here is where you would decide if you want to leave any of your assets to a charity of your choice. Say, for example, you want to give it to Human Rights Watch. You would decide how much, the percent of the residual trust property you would like to leave to Human Rights Watch, and a message to them if you want. And here is where you would plan out who is your primary beneficiary. So you automatically create a custom plan, and down here, you would add a person who would get how much of your trust. So for example, John Doe, he'll get 100. But if you don't want to do that, say you only want to give him 50%, you would need to add another person or charity to give the other 50% to. So all your beneficiaries, they have to, the allocation has to add up to 100%. And this is where you decide the secondary beneficiaries. So if John Doe doesn't survive, do you want to leave it to charity, leave it to their descendants, create a custom plan, as in you would decide yourself, the specific person or charity, or you want to split it among the other primary beneficiaries. So let's say we'll do that. And this is the other beneficiaries, the other primary beneficiaries. So like I put 2, so if John Doe doesn't survive and Ellen Smith doesn't survive, this is the same process. And this is the summary, so you can edit if you find out you made a mistake or you want to make some changes. And next up is the property. So it asks you what type of property you're adding: jewelry, real estate, financial account, others. And you'll have to specify what that other is. Maybe like, I'm not sure. So like maybe antique furniture, I don't know. Or an antique, like an antique grandfather clock that's worth a lot of money. So for an example, I put jewelry, and you would specify a clear description of the property, describe what it looks like, if it has a title document. Real estate, you would have to put down the address and if it has a title document. Financial account, you have to describe like the bank account, if it's a checking or savings, you would put that there. And this is the specific gifts. And for specific gifts, this is where you decide who specifically will these items go to. So for the property I put, it's sapphire necklace, and I specifically wanted to give it to Ellen Smith instead of, say, my other primary beneficiary, John Doe. And if she doesn't survive, I'll give it to her descendants. And this is how it would look. So like create a custom plan or leave it to charity. And you would put down the person, right? And if you want it, and if she doesn't survive, do you want to leave that property to charity, her descendants, another specific person, or just leave it to be distributed with my residuary property? Once again, this is the preview if you want to make any changes. If not, then next. And next is the custodianship. As it explains, it can be tricky for young people to manage a valuable inheritance, but a custodian can help. A custodian is a person that manages gifts left to a minor or a young adult until he or she is older. If you are leaving any gifts to someone younger than 25 years old, you can use your trust document to appoint a custodian to help them manage those gifts until they are older. And ask you, do you want to appoint a custodian? If yes, click next, and it'll bring you to here. And it'll list all your primary beneficiaries, and you would have to put down, add a custodian, put down the full name and the relation to them or to you, and what age do you want the custodianship to end. So if the person is 20 years old, that's when the custodianship will end and they can manage the property by themselves. And next is the funeral wishes. In order of preference, who will be responsible for carrying out your funeral and final resting place instructions? This is all optional, but if you want to specify exactly who will be the one to carry out your funeral, you would of course add the person's name, their relation to you, and what are your wishes for your funeral service? What wishes do you want for your body and final resting place? And if you want any charities you want your loved ones to support in your memory. And next will be the provisions and miscellany stuff. So I'd ask you, would you like to include a non-contest clause in your document? A non-contest clause is a provision that discourages challenges to your estate plan. It states that anyone who baselessly challenges the distributions you've made will be treated as though he or she predeceased you. In other words, they will not receive any gifts you have left them. If you want to include that, click yes or no. Next. And this is the last step. This is where you review all your entries and check for any mistakes or any missing things. And if you want to make any changes to any of these sections, you would click edit.
Hey, Amy, forgive me for interrupting you, but would you go back to that one about contesting?
Yeah.
What was that term?
No contest clause.
Click on that. Click. Oh, you did click yes?
Yeah, I click yes.
Oh, I'm sorry. My mistake.
Yeah. And this is just the question mark gives you more information about it. And how likely is a no contest clause to be actually enforced? No contest clauses are narrowly enforced in California. For example, if a beneficiary challenges a provision, but the court finds that they had probable cause to believe the challenge might succeed, the court may not enforce the clause. However, the mere presence of a no contest clause in a trust document may suffice to discourage frivolous challenges.
Thank you.
So once you reviewed all your responses, save and continue, and that's it. That's done. You could download your documents, you can email it to you, and that's it.
Very good, Amy. It's a little more to it than that, because if you own property, you'll have to get your deed transferred from your ownership to the trust ownership. You still have all of the rights you have now. That's how it avoids probate, because the property is then transferred from Jorick Gaines to the Jorick Gaines Revocable Living Trust. So when I make my transition, the trust now owns it, and my successor trustee that I've named steps right in as soon as they have my death certificate and confirm any act that I have given them permission to do, including sell the property, refinance it, repair it, anything that needs to be done. I like to call it controlling your wealth from your grave. As long as you have a trusted person that acts as your successor trustee. So I'm going to do a little quick presentation here. This is, I think this is important. Quick PowerPoint, and then we'll take some questions. I'm going to talk fast because I want to get to the main part. So I'm going to, Amy, do I have the ability to share my screen?
Yes.
Okay, great. Where's my, oh, maybe it is working. No, it's not working. I'm going to get it working before I come to you guys. So I'm working from 2 screens here. I think it'll work. So if I'm not looking at you guys, that's why. So, oh, I opened it. Let me share my screen because that's important. First of all, I just want to share with you our mission. Can you see that okay? You see that mission? So our mission at WealthWave, the How Money Works company, is to teach 20 million families how money works within the next decade. How are we going to do that? You see that book in the background, How Money Works? Stop Being a Sucker. I'm going to be Oprah today because Bev, you, Jackie, Johnny, anybody that wants a book gets a book for free. All you have to do, send me an email or text me. You have my information in the chat. And I ask that you not put it on the shelf. And I also ask, I would love to hear your feedback and tell me what you learned that you didn't already know. And the last request I have is teach it forward. When you finish with the book, I recommend, the book even recommends you read it at least twice, and then share it with someone else. Let's stamp out financial illiteracy. That's what we're all about. And that's really what a lot of this stems from. Just so you know, not knowing how money works in last year alone cost Americans $415 billion. That means it didn't go into your family's bank account. It went into the large financial company's bank account. That is over $1,600 for every American in the country today, over 230 million of us. So this is critical. Well, I thought I could block those screens. So we have a 7-step approach. I'm not going to go through all of them, but financial education, property protection, emergency fund, debt management, cash flow, building wealth, and number 7 is where we're focused today. Protect your wealth. It doesn't do you any good to work 40, 50 years, pass away, and leave it to the attorneys, the state, and the federal government, because that's where it's going to go. Because if you don't have an estate plan, you default to the state of California's estate plan, and it's called probate. So, God, I thought I blocked these out. So most of you have probably heard by now, Prince had an estimated value estate of $150 million. Aretha Franklin, $80 million. Neither had an estate plan. 64% of Americans do not have a will. That's why this is so important. The will is free. If you don't own a property, you probably don't need a trust, but you need a will. Your estate plan is how you protect your wealth, your family, and your legacy when you die, if you incapacitated. It's a set of documents, including your will, used by your loved ones to carry out your wishes and decisions. Don't leave it to chance. So the 4 documents, as Amy has gone through in our, I think it's 4 presentations that we've had. It has a will, there's the financial power of attorney, it has your advanced directive or living will, and then your health insurance portability, HIPAA. And I'd also like to add on the HIPAA form, if you have kids that are over 18 and you are grandkids and you are their financial provider, if you will, and if they go into the hospital and in a coma and saying there needs to be emergency surgery, you can't make that decision without your help, without your HIPAA release. So get that on all of your kids as well, because if they get in an accident and they're over 18, you don't automatically get to tell the doctor what to do, and the doctor cannot share with you any of their medical records either. All right, so having an estate plan in place can help you avoid the government making decisions about who gets your property and who takes care of your children, or if you have children's children. The process of a court administrating estate in accordance with state law is called probate. And if you've ever been through probate, you know it's something you don't want to do again. So I think we mentioned, but trust can manage your property, protect the interest of your children, protect special needs, and that's a big growing area in the legal field. Special needs children, because special needs kids need care all of their lives. What happens when you leave? Provide privacy. Just so you know, if you die without a trust, everything you own in your probate file at the county recorder's office is public record. When I used to sell real estate back in the 90s, in the 80s actually, 80s and early 90s, I used to go to the courthouse and ask for the probate file so I could see who died and who had property, so I could contact the attorney, the probate attorney, and see if they needed a real estate broker. And I also got to see what stocks they own, how much they had in their plan, their pension or their retirement. Or hey, here's my question. Do you think the people operating scams know how to do that? Your stuff is public. With a living trust, it's private and it's immediate, as opposed to probate, which can literally take years to finish. So avoid probate in multiple states and lower your estate taxes potentially. I don't want to get in that, open that can of worm. All right, let me go back. So you think estate planning will be too expensive or time consuming, then you haven't considered the cost of your loved ones down the road. The truth is there are options for almost every budget. And the one we introduced today is for someone that has no budget. It's free. My favorite word, my favorite price. If I ever go buy anything and they say it's free, I am, Bev, I got a feeling you're getting ready to ask something.
So getting the will is free, but the living trust is not, right?
The
That you have to
living
go through
trust with Freewill in California is free.
So I can go to you or an attorney and my
No.
trust. Okay.
Freewill.com is the only place you're going to get a free living trust. Now, it's not
Okay.
totally free because you still have to record your documents, get whatever needs to be notarized. So you have to pay somebody to do that. But generally, the attorney in California charges anywhere from $2,000 to $3,000, and I've heard even $3,500.
Yeah.
So it just depends on what attorney you're dealing with and whether it's their specialty or not, or whether it's something they don't really want to do, but it's good money.
Okay.
I have an attorney friend. He and his wife are attorneys, and he said, I'd rather people not get a living trust because I make more money when they don't. And I'm going to show you what I mean in just a minute. Let's say you could get one for $2,500, because that's where I'm headed next. So California probate. The question is, do you need a probate? The bottom line, in the state of California, if you have an estate valued at over $150,000, then it will have to be probated. So let's put it, if you own a house, you need a living trust in California, because it's going to be worth more than $150,000. You can't get a garage in the Bay Area for $150,000. So I'm going to just go skip through that class. So here's where I want to get to. In California, there's several common and effective ways to avoid probate when it comes to passing on property or assets. Estate is less than $150,000, revocable living trust, non-revocable living trust, joint ownership of your property, transfer on death, or payable on death. Those are ways to avoid those items that you can put on the properties, avoid probate. Lawyers and executor fees. Both the executor and the attorney will be paid per California's statutory fee schedule. If you don't know what statutory means, that means you don't avoid it. You can't negotiate it. That's the fee. That's what it is. Now, attorney could charge by the hour, usually a minimum of $350. This is probably a little dated. I think it's more like $450 to $500 an hour, or a flat fee, but most will want to go based on the percentage. Why do you think that is? You can get an idea of how high these fees are by looking at California's statutory fee schedule. For ordinary services, a lawyer executor can collect. Now let me cover that ordinary in quotes, meaning nobody's fighting and it's a simple do the probate, transfer the properties, and you're done with it. That's almost unheard of, first of all. So 4% of the first 100,000 of the gross estate, meaning if you own $1 million house and you owe $1 million on it, it's still $1 million gross. 3% of the next 100,000, 2% of the next 800,000, and 1% of the next 9 million. Most of us stop there. And a reasonable amount, anything over 25 million. So let's look. I'm going to skip all the way down to 600,000. If you have an estate, a gross estate, and that's everything you own at the time you died, is 600,000. I start there because if you own a house, probably it's worth at least 600,000. Then the attorney and the executor gets paid 15,000 each. That's 30 grand, assuming it goes smoothly with no problem. And again, that's very unlikely. 700,000 is 17,000, 19,000 times 2. Incidentally, everything you see here is times 2. 900,000 is 42 grand, and $1 million is 46 grand. And you can see where the rest of it goes. So you can see spending $2,500 is nothing compared to what your family is going to have to pay out of your estate, which you slaved for years, decades, to give to the attorneys and the government. not to mention taxes and other expenses that could be due. So I suggest you get with a professional and discuss it one way or another, whether you choose the free route or an attorney or something in between. And there are a couple of other options. We have digital platforms. There are, what do they call them? I'm losing my term, having a senior moment, as they say. Paralegals and other people that prepare trust, but don't procrastinate. The only reason you should procrastinate is if you know what that last number after the dash is. You know, I was born in 1957, dash, when I'm gonna die. Unless you know when you're gonna die, then you can procrastinate. If you don't know, I suggest you do it right away. So don't procrastinate. All right, so that's my contact info. Again, I put it in the chat. Jorick Gaines, jorick.gaines@wealthwave.com. And I'm actually in the East Bay. I'm an investment advisor as well, and I have to put my branch office on my business card. So you can jot that down. Any questions? Do we have any questions, Amy? Nope, I don't see any in the chat. Anybody have a question?
Come on. Can you go back to the last slide that you just had
Sure,
of the breakdown?
sure.
I'm taking a picture.
Go right ahead. Now, you might want to check the state of California. This is probably 3 years. I was getting ready to say 2, but I forget about COVID. So this is probably 3 years old. I don't think it's changed, but matter of fact, I know it didn't because I did this in August and I checked my numbers before I did it. I did a presentation for Phi Beta Sigma, and that's anyway, a women's sorority. So no questions. We did that good of a job, Amy. Amy, you're awesome. Bev, any other questions?
I don't think so. I got a lot of things I have to get together, but I definitely want to do this and not procrastinate.
I have a question. Anybody been through probate for another family member or been an executor on a probate estate? I used to sell, you know, I got all kinds of stories. As I told you, I used to sell real estate, and I remember, this is an extreme case, but they happen. First of all, I had a real good friend. Don't make this mistake, Bev, when you do yours. Name only one successor trustee, not 2. You might name an alternate, but don't. And I have a good friend whose mother named her and her brother as co-successor trustees, and they didn't even like each other. And it was a fight, and it's been a fight, and it's been a fight for over a decade. It got so bad that the judge dismissed both of them and appointed a private trustee to manage the trust. And you don't need to ask. That's not free.
Yeah.
And another case where we were selling a house, about to close escrow, and the nephew of the lady that died came up and said, my aunt wanted me to have a part of this house. And the kids say, man, you crazy. He got an attorney and filed a les pendus, and they could not sell the property. So all kinds of things happen. If the property is in a living trust, does it have to come out of a trust to be put in? If the property is in a living trust, does it have to come out of trust to be put into? Okay, Peaches, I'm not sure I understand. If it's in a living trust, why would you want to take it out? Oh, is someone, can you unmute yourself?
Yes, my mother put the property in a living trust to me.
Okay.
She's deceased.
Okay.
So now I want to be able to have my own living trust to pass the property on. What do I need to do?
You need to establish a living trust and go through all of this process for yourself and name your successor trustee. So when you make your transition, they know who it goes to and all of your final wishes are taken care of.
So I don't have to do anything about the trust that she set up.
Well, that's a legal question, quite honestly. I've not had that question before, but So it depends on how the trust is structured, because you could actually have a trust go for generations. I think you can have it go up to 99 years after your death. So it depends on what the language in the existing trust is. And
It's
what
just to me, it's just me.
well, in that case, I would guess, and please don't take this as legal advice, because I am not an attorney. I
Gotcha.
would guess that you can transfer the title from, because you're the successor trustee, so you have full rights to do everything, especially since it's just you. So
Yes.
then you should be able to create your trust, and then you would have to deed the property from that trust to your trust, which you would be the trustee as long as you're alive. And then when you pass, your successor trustee would step into your shoes. Does that make sense?
Kind of, sort of. So would I need to get legal?
Probably.
Okay.
You'll need to consult with somebody to make sure that it's necessary, A, and B, because I'm sure her trust does not name a successor to you. Well, I'm not sure of that, but it probably doesn't.
No. Right.
So then, yeah, you need to get someone that's going to step in your shoes once you transition.
Right.
So
I don't
yeah,
want to leave it to
go
the
ahead.
state. I don't want to leave it, you know.
Yeah, and if it could get even messier, because there was no provisions in the existing trusts for what happens when you leave. So yeah,
Right.
you really need to get some advice on that and get that taken care of. If you need a referral, let me know.
Okay.
You have my contact info.
I
Okay,
sure do.
Contact me anytime.
I
Bev, you look
sure
like
will.
Bev. Did you want to
Thank
ask something? You're very welcome. My apologies.
I'm typing it out to you.
Oh, okay. Okay, very good. So yeah, it's not easy, and you know they're irrevocable and revocable trust. Not the detailed information as you see it on the screen right now, Amy. But it does talk. Matter of fact, if I go back, Amy asked, you guys can probably see that it's some of the information. Some of the information is in our book, not the dollars, because this book is a national book and it varies by state. This is regulated by the state, not the Fed. So like the pages you see here with the little icons and this, a lot of this is in the book. This comes right out of the book. So, but we cover all of those 7 steps. So, other questions? What did you ask, Bev? I don't see it.
Didn't come up?
I didn't see it. Let me see if you went ahead of Amy. Nope, it didn't come up.
Okay, I'll ask it. Okay, so to name your trust, when there's a husband and wife situation, should it be in both their names?
Absolutely. If
Exactly.
you're married and you own the property together, generally it would go from Jorick and Deborah Gaines to the Jorick and Deborah Gaines Revocable Living Trust.
Okay.
Because generally what happens if you're married and you own property, and this is a community property state. So when I die, let's say I die before my wife, she still owns the property. The trust still exists. Now she'll have to amend it. So anything that in there that relates to me will have to be changed, but then she becomes the trustee or vice versa. And then when she passes is when all of those instructions have to be taken care of.
Okay.
But in today's world, since 50% of divorces are marriages in divorce, a lot of times there are cases where the husband has kids by a previous marriage, the wife has kids by a previous marriage, and how are the assets going to be distributed? So that needs to be discussed and in writing. Otherwise, it's a real mess. And I'll tell you another scary story. How much time we've got? Okay, we'll finish in 5 minutes, hopefully. I'll tell you a case where the kids were disinherited unintentionally. So for instance, let's say I'm married, my wife dies, everything comes to me. And of course, it's in the trust or however it is, and then I die and it goes to my new wife. My new wife doesn't make provisions for my children. She dies and all of her family gets all of our assets, my kids get nothing. So you got to make sure and have conversations about that, put it in writing, get legal advice if you need it, and make sure it's structured properly. Yes, it's not free, but it's worth it. And this is simple. If you got a simple trust, you can use this free one. But if you have a complex trust with multiple properties in multiple states, advice, free advice, get a legal professional. Because when you enter in different laws in other states into your trust, it gets complicated. So it's not easy. It's no fun, but not to do it is shameful, quite honestly, in my opinion. All right, let's see. Hi, if the property is in, okay, that was answered already, I think. Amy, and then question from Johnny Evans, but there's no question, Johnny, if you want. Oh, was that Johnny Evans I talked to earlier? Okay, Johnny's not here. I don't see Johnny. All right, if there are no other questions, again, you have my contact info. If I can't answer the question, and again, I'm not an attorney, that's my disclaimer, I can definitely direct you to one. So again, I want to say thank all of you for coming tonight. We really appreciate it. We hope you learned something and it was worth your time. And again, share it with the people you love. Make sure that, I know you can't tell them what to do, but keep on them. Be like that raindrop on the concrete. If you drip long enough, it'll make a dent. So thanks everybody. Have a great night, great week, and a great weekend.